All right, let me get to.
So we'll come out on Friday and go through the questionnaire. We don't get any questions on that.
All right, the defendant had filed two separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
All right, and I'll ask the deputy county attorney. I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right. Based on the states of Vallow, I don't know, I can't tell them to turn over something they say they don't have, so I'll find that the state, based on their Vallow and officers of the court, have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. Okay. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed, and you said the 2-hour interrogation that Gilbert released?
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed, is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
We disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over,
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
let me see if we can find the actual
Maybe the discovery notice. date.
discovery letter.
Okay.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this, have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. She said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply to?
Specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
that he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. So you're asserting excited utterance, some of these statements come in. What else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B5B, the recorded recollection of his police interview and the body cam footage, applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with, does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't.
Are you referencing what time he was interviewed versus the time of the incident?
Let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when
roughly.
the 911 call was made. So we have soon after that the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station, and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Tylee made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview, saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's police interview.
All right, anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right, the court is on a preliminary basis precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced.